Wells Fargo, Wachovia, but it says their dilemma is they hate to love niggers and love to hate niggers.
This is John Singletary, Charleston, South Carolina, and another edition of the Courtroom of Public Opinion, bringing to you information on Wells Fargo and the Wells Fargo versus Singletary case. Last time we talked about Wells Fargo, their statement that Wells Fargo loves to hate niggers and hate to love niggers. We talked about the fact that Judge Bristol Marchant had in fact altered documents that go to the Judicial Conference. The documents that are mandated by the Civil Justice Reform Act of 1990 that says that they have to report any outstanding motions every 6 months and every year for the outstanding cases. Now, in this case, which grows out of another case, this case grows out of the case for Singletary versus North Charleston. And in that case, the Singletary versus North Charleston case, there were 6 federal judges on the case, 6 federal judges. There was Judge Carr, Robert Carr, Judge Bruce Hendricks Howe, Judge Bristol Marchant, who incidentally was never assigned to the case. However, he made 8 rulings in the case despite he was not assigned to that case. The other judges on the case were Judge Margaret Seymour, Judge David Norton, and Judge Richard Gergel. Judge Margaret Seymour gave an order in the case, compelling discovery, in which the defendant refused to adhere to the order that she issued. A default was requested. However, she refused to enforce her own order. In fact, she was then removed from the case, or removed herself from the case, whichever, I don't know. Finally, the case went to Judge Norton and then to Judge Richard Gergel. Now, Richard Gergel, should I say the Honorable Judge Richard Gergel, was nominated by our own James Clyburn and confirmed by President Barack Obama. However, since he's been in office, what he has done is he has simply denied African Americans the right to a fair jury trial through the abuse of pretrial adjudication. What he has done is he's denied due process and equal protection of the law. Case in point, the standard of review for summary judgment, Rule 56, says that there has to be, if there are genuine issues of material fact that are still present, that he does not have the authority to grant the summary judgment. It must be passed on to the jury so that the jury trial is not circumvented. And there's some stipulations with Rule 56 that deals with the Federal Rules of Civil Procedure, Rule 56, that deals with why a summary judgment should not be granted. In this case, there are many competing affidavits which bars any granting of summary judgment. There's an outstanding motion by Judge Seymour compelling the defendant to give discovery, and so there's still open discovery. However, through all of this, and through his acknowledgement and admission that there are still genuine issues of a material fact present, he still issues a summary judgment in the case. Now, you can say, well, you can appeal it to the appellate court, then if necessary to the Supreme Court. That was done. When the appellate court refused to even hear the case, you would wonder why in the world would such a thing happen. Well, we need to take a look at the long-standing history. The fact that Judge Traxler is the Chief Justice there, and Judge Traxler, when he received the complaint on Judge Marchant, Judge Bristol Marchant, that said that Judge Bristol Marchant was part of a invidiously discriminating organization that violated the canon of ethics and that it was prohibited by the canon of ethics, he said that there was nothing wrong with that. However, in the Bell-Mead case, the Bell-Mead case dealt with the identical situation with Judge Payne, who belonged to an invidiously discriminating organization, and a white female, that we are glad that she got justice, but she was able to, for the first time in the history of the United States, take advantage of the Civil Justice Reform Act of 1990. That was primarily for the protection of African Americans and being able to go to the judicial system and receive justice without having to deal with judges who sat on invidiously discriminating organizations. Judge Bristol Marchant belongs to 6 such organizations. 6 such organizations. And Judge Traxler, who is on the committee that reviewed the Bell-Mead case. And in that case, they said that no, it's not possible that this could happen, that what he did was wrong, it's a violation of the canon of ethics, and if he doesn't resign immediately, we will fire him. However, in the situation with Judge Bristol Marchant, he says that it's okay. That, well, he says that he doesn't belong to it anymore. Well, still, it was prohibited since 1990, and he was a member since then. He sits on cases today denying African Americans due process and equal protection. These are the kinds of injustices that we must deal with in our judicial system, because if we do not, then there is no way for our race to progress. This type of thing, like I said earlier, is part of a Judge Roger B. Taney mentality. And speaking of Roger, the initial case with North Charleston, that was an appeal from a zoning issue that went to the circuit court for the state of South Carolina. And sitting on that case was Judge Roger Young, who, when asked to recuse himself, refused to do so. He said he knew no one in the city of North Charleston that was involved in the case. However, his long-term friend from the Dixie Youth Baseball League, and you can take a look at the history of the Dixie Youth and how they came to be. Also, they were friends in high school, went to R.B. Stall, played baseball together. Judge Young himself worked as a judge in the city of the North Charleston office for the defendant, as well as he was the city attorney for the city of North Charleston. And yet he says he knows no one who's connected with the case. Not only his lifetime friend, Brady Hare, who had just left the courtroom, but he grew up in North Charleston, worked for North Charleston. And when he was asked the question to recuse himself, and later it was brought to his attention that you worked for them and you were, they were a client of yours as the city attorney, he said in writing that he forgot he used to work for the city of North Charleston. Judge Roger Young stating that he forgot that he used to work for the city of North Charleston. And all that's awful, but what was even worse, and a kick in the teeth, is that the South Carolina Misconduct and Review Board said that they saw nothing wrong with what he did. Now, the question that was posed to them was whether or not Judge Roger Young should recuse himself, and should have recused himself on the case, knowing that he was a judge in North Charleston, that his long-term friend was before him, and that he was the city attorney. Now, the Misconduct and Review Board, who was also given the information that the counsel asked Judge Roger Young, are you going to listen to the merits of the case today? And he says, absolutely not. Not today, just want to get an idea of what's going on. Haven't even read the case. Hear a few words from each side, then we'll have another hearing and proceed. So not going to listen to any of the merits. However, he immediately turned around and gave an instant decision in favor of North Charleston. Incidentally, at least 15 cases, well, all the cases that we were able to research and find, he's always ruled in favor of his previous employer, the city of North Charleston. Yet, he says that he doesn't know anyone there, that he can be impartial. The South Carolina Misconduct and Review Board says that, hey, just because you're upset with the decision doesn't mean that we need to say or do anything or investigate the judge. When the question was not whether or not the verdict given by him was just or unjust, but the fact that he even sat on the case. However, they've refused to deal with that. Now, they've got another one that's in front of them that deals with Judge Mikhail Scarborough. And we'll see how, and we'll bring to you the results of that. But, as I stated, every day, twice a day, we'll be bringing you video to explain to you and to show you documentation of the different types of networked racism that exists in South Carolina. We're still living here under a Judge Roger B. Taney mentality because the system is fundamentally flawed. Many of the statutes, many of the laws that we have, facially, they're neutral. However, they're applied in a discriminatory fashion. And as a result, justice is not served. Recently, Judge Richard Gergel, at the unveiling of the statute for Judge Waring, talked about how justice should be served. He also, in an interview, said that he just could not understand how a Confederate-raised person like Judge Waring could fathom or even be involved in the separate but equal. How can he even conceptualize separate not being equal? We've been raised here in the South all our life. And as a result, he should have gone with the majority to say that blacks should not be allowed to integrate. And now he sits in Judge Waring's seat and wholesale denies the right to a jury trial based on our research through pretrial adjudication. He denies the right to jury trials for African Americans in South Carolina. Think of how awful that is. That has to be dealt with before South Carolinians who are African American and Latinos get any type of justice in this system. And so we're asking the Department of Justice to come down and to simply do an investigation to see whether or not that is happening. They need to come and take a look at to see whether or not the summary judgment that was issued in the case for Wells Fargo versus Singletary, the case for Singletary versus North Charleston, the case for Singletary versus Allstate, the case for Singletary versus the procurement for South Carolina, and I can go on and on. But what's happening is that we are being denied the right to due process and equal protection because we have an ingrained discriminating system of justice in South Carolina that does not allow a breakthrough. When you deny a litigant not only the right to subpoenas, the right to discovery, and yet after 1,000 motions into the court system, never being able to go before a federal judge, all of it being done through paperwork because you're a pro se litigant, then there is a problem with the judicial system. There's a problem. Many motions not addressed, as the Civil Justice Reform Act requires. Incidentally, what happened is that when the reports are pulled automatically, they go in, they close the cases, then they come back and reopen the cases. Or on the report, the manipulations happen such that for Judge Bristol Marshall, you'll see that there are absolutely no outstanding motions. However, I can document proof within the PACER system that the motions are not being addressed by him. One such motion was for fraud of the court by an attorney who is now a judge, who submitted false documentation to the court that was proven to be false. However, he refused to address that motion. And refusing to address that motion during that time, she was up to become a family court judge and has become a family court judge. Knowing that that kind of thing is being perpetuated and not dealing with it is a responsibility of the Department of Justice that has to be addressed. My name is John Singletary, and I'll be seeing you soon. Thank you.